Call to order. It is 6:31 PM on September 8th, 2025, and this is the regular meeting of the Monroe Township Zoning Board of Adjustment. Notice of this meeting was given as required by the Open Public Meetings Act, and a copy was posted on the second floor bulletin board in Town Hall and on the township's website. Please be advised, no new item of business will be started after 10:30 PM, and the meeting shall terminate no later than 11 PM. Please note, audio and video of this meeting is being recorded in accordance with Ordinance 56-2024. The meeting is being broadcasted live on the township's YouTube channel, and a link to view this meeting will be posted on the township's website for public to view at their convenience. Everyone please stand to salute the flag. Started by Mr. Kozak. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call.
Mr. Carino? Here. Mr. Colavita is excused. Mr. Comiskey?
Here.
Mr. Footer?
Here.
Mr. Hefner?
Here.
Mr. Kozak?
Here.
Mr. McGeehan?
Here.
Mr. Rice?
Here.
Mr. Heverly is excused. Mr. Fury?
Here.
Mr. Warburton?
Here.
And both alternates, you will both be voting tonight.
Okay. Oaths.
Okay, swear in on professional planner. State your name for the record.
Adam Warburton?
You swear affirm to tell the truth and nothing but the truth.
I do.
Thank you.
Resolutions, Mr.
Okay,
Fury.
there are 8 resolutions on for adoption this evening. If you so choose, you can handle that by way of consent agenda. The first resolution is R 25-25, Denise and Rich Bush, buffer encroachment variance approval. Second is number 31, 2025, Carter Airstrip 1 LLC, preliminary and final major site plan extension approval. Number 32-25 is Carter Airstrip 1 LLC, use variance approval. The next is number 33-2025, Raritan Growth LLC, use variance approval. Number 34-2025, Raritan Growth minor site plan approval. Next is number 35-2025, Anthony Ocello, lot coverage, side yard and rear yard variance approval. Number 7 is number 36-25, Brian and Rhoda Conwacky, amendment of prior approvals. And the final is number 37-25, John Lash, request to amend approval, which was denied.
Members, your pleasure in regards to resolutions 1 through 8.
Motion to approve.
Second.
All in favor?
Aye.
Opposed? The ayes have it. Yeah. Okay, applications. First on the agenda is application 25-18, Highland Development Group LLC, lot area variance and lot frontage and lot width. Can this application be deemed complete? Yes. Is there a motion to deem the application complete?
So moved.
Second.
All those in favor?
Aye.
Opposed? The ayes have it.
Good evening, Leonard.
Okay.
Leonard Schwartz, law firm of Slotting and Schwartz, representing the applicant. Greg, come up here and Vince. Just get sworn in.
Okay, whoever your witnesses are, gentlemen, just state your names and addresses for the record individually.
Greg Simons, professional engineer with Ewing Associates from Clayton, New Jersey.
Vincent Yanni, 1 Lee Court, Barrington, New Jersey. I'm a member of the applicant.
Okay, you both swear affirm to tell the truth, nothing but the truth this evening.
Yes.
Thank you.
Very briefly, this is a property on Pittman Downer Road, block 14801, lot 35. It's vacant property, 0.4 acres. The proposal was using it as a single-family dwelling. The variances are for a lot size from 1 acre, proposing 0.4 acres. The lot frontage, the requirement in the area is 120 feet. We're asking for 100. Minimum lot width required is 150. We're proposing 100. Other than that, there were, as the testimony will indicate, there were no other variances requested. All the side yards, rear yards, etc., are all covered as and meet all the township requirements for this property. I'll have Greg go through the plan with you. I'll let you know exactly what we're proposing. All right, want to take the microphone
property that was submitted. This is a copy of the grading plan, the plot and grading plan. It's lot,
Excuse me. When they're done, they're going to put it out in the center so everyone can see it.
property is 100 feet wide by 201 feet depth. It's 17,503 square feet, or 0.4 acres. We comply with all the building setbacks. So we have the building setback at 60 feet, where 60 feet is required. Sides are at 20 feet, and we have 21.5 and 25 on the other side. And we comply with the rear yard setback. It's 50 feet. It's set at 79.0 feet. Septic approval was granted for this project. And we went through the variances as listed by the applicant's attorney. And we do know that there are some other undersized lots further down the road, on Pittman Downer Road, that are less than 1 acre. Show the driveway, basically in the middle of the property, coming off of Pittman Downer Road, 60-foot long driveway. Septic system is in the rear yard. The proposed well is in the front yard, over 105 feet from the proposed septic system. And I believe it's a hardship because it's an existing non-conforming parcel.
Regular parcel, with regard to septic and well. The well is in the front of this property.
Correct. The proposed well is in the front and left, or the middle front of the property, and the septic is in the middle back of the property.
And in terms of what are the requirements of the septic being the distance from the wells?
It needs to be a minimum of 100 feet from any well, which we meet that requirement, and 50 feet from any adjacent septic system, which we meet that requirement as well.
In regard to grading and drainage, we've submitted to the township a grading plan to make sure that the proper grading for this property.
We have prepared a grading plan. Roughly the drainage comes up towards the front of the property, towards Pittman Downer Road. The road is a little bit higher than the property, so there is some low areas in the front of the property. But we have proposed drainage coming from the rear to the front of the property.
So the drainage that, when the house is being built, the drainage will be going toward Pittman Downer Road and not on the property inside.
That's correct. That's how we have it proposed.
Okay. There's been some conversation about drainage issues today, property flooding. Once the house is being built, how are your plans proposing to cover that?
Well, it does need to be submitted to the township for grading plan review. We may propose some stormwater management mitigation manners to collect some of the drainage and absorb it into the ground.
With regard to the property itself, in terms of undue hardship, what you're saying is that this property is exceptionally narrow compared to the other properties in the area. 100-foot walking width instead of 120 or 150.
That is correct. There are some narrower lots further down on Pittman Downer Road towards the intersection that are also undersized.
I think I looked at the tax map that indicates that along that side of the road, there's one lot that's 60-foot wide, 4 lots that are 100-foot wide, including the lot next door, lot 36, a 100-foot frontage on the fronting Pittman Downer Road. Across the street, 6 lots that are 100-foot wide, fronting on the Pittman Downer Road, and 1 lot that's 50.24. If you look at the tax map, if you want to check
I have a copy of the tax map. That's what I was referring to as
Maybe
well.
just for the record, if you could just confirm what the attorney, because he can't testify, you're testifying that his representations are accurate for the record?
Yes.
That's the size, okay, thank you.
Through the chair, at this point, Len, these are developed lots that we're talking about, people have houses on them, not all of them, but some. Not all, some, there are houses on small. No, just, no, we're good.
I'd also like to note that the maximum impervious coverage permitted is 40%, and we currently are proposing 15.6%. So well under the maximum impervious coverage.
I see somewhere you're bringing a basement going in there?
That is correct.
Yeah, not for basement. Okay. In all the plans, you noted that there are location of the various septic systems and wells, or as you said, far away, they meet all the requirements for the county improvements.
Yes, they did get Gloucester County Health Department approval for the septic system with no deviations.
I have nothing further, this one.
Okay. Members of the board have any questions for their professional?
Yeah, just one through, with Len, through the chair. The hardship, there was no way they could buy additional land that's adjacent to theirs to comply with vacant land?
That's true. Vince is going to testify.
Okay, very good, thank you.
Okay, you can bring up your next.
State your name for the record, please.
Vincent Yanni,
And you are one of the members of this
one of the owners of
organization.
the, yes, of the developer.
Now, with regard to, let's go to the specific question. If we're looking at this property to the left, lot 36, it's already developed with a house on it,
Correct.
and lot 30, is that lot 34 next door on the other side? There's also a house there?
Correct.
Okay. So is, and in the back, that is part of lot 36?
Correct.
So there's nowhere that you are going to buy any additional land in order to make this a 1 acre lot, correct?
That's correct. Both houses on the sides, it did not appear that there was any opportunity to gain sufficient land from them to be conforming without affecting, them being too close on their setbacks.
You indicated to me when we were talking that you had been in contact with the owner of lot 36 with regard to the sale of this property to lot 36.
Yes, we had some discussion early on prior to us submitting for the septic and deciding to move forward to see if that owner was either interested in purchasing this lot or in selling us additional land in the back to make us larger. There did seem like there had initially been some interest, but I'd given her ample time to come up with an offer or to substantiate it, and after about a month, we decided to move forward with attempting to develop the lot ourselves.
And we went forward with this a couple months ago, if I recall.
We started it at least a couple months ago, yes, doing the soil testing and the surveying and engineering work on making sure that the lot could support a septic system and well.
Matter of fact, this grading plan is dated April 25, 2025. So that was
Correct.
prior to that.
Yes,
And she did not get back to you with regard to wanting to buy this land or sell you any of her land.
correct.
Did you do a title search on this property?
Yes.
Did you find any easements on the property?
To my knowledge, no. There was,
So there's, to your knowledge, there was no easement on your property creating an easement from the Pittman Downer Road to the rear of the property to where lot 36 is in the back.
that is
Correct.
correct, that I did not find any easement in that regard.
What are you proposing for this property?
It's a two-story, single-family home. It's going to be approximately 2,200 square feet of living space, 4-bedroom, 2.5 bath with a 2-car garage.
You have a well in the front
Yes,
and a septic system in the back.
correct.
And based upon the testimony, with regard to any drainage issues, can we assume that you certainly don't want to sell a property to anybody that's going to have their house flooded, especially a 9-foot basement?
Absolutely. We are certainly in agreement to comply with whatever the engineering department recommends and, you know, requires us in terms of the grading and drainage plan.
As your engineer said, there may be water that's 50 down the road, it may be higher than your property, so it may require filling of your property. in order
Understood.
To be able to make sure you're not flooding out.
Yes, whatever they require, we're on board with.
Nothing further this witness.
Okay. Link. Okay. Len, you have nothing else right now, right? Okay. Any questions from any members of the board for the applicants? Okay, is there a motion to open to the public?
I just want to move it a little so the public can.
Get up to the podium at least. Or maybe forward a little bit. Is there a motion to open to the public?
So moved. Second.
All those in favor?
Aye.
Opposed? The ayes have it. Is there anyone from the public wishing to speak on behalf of application 25-18? Please step up to the microphone.
Okay, miss, if you would just state your name for the record and your address.
My name is Michelle Boyle.
Okay, and you swear affirm to tell the truth, nothing but the truth this evening. And your address.
I'm sorry, I can't hear.
Your address.
My address is 1516 Pittman Downer Road. I am lot 36.
Thank you.
Okay.
Good evening.
Good evening.
My name is Michelle Boyle, which I've already told you. I live at 1516 Pittman Downer Road, directly adjoining lot 35. I strongly oppose this variance, as lot 35 is approximately 60% undersized compared to current zoning requirements. This is not a minor adjustment. This is a massive nonconformity. Zoning laws are not suggestions. They are the law. They exist for a reason, to protect public health, safety, and welfare, to ensure orderly development, and to preserve the character of neighborhoods. To bend or ignore these laws would undermine the integrity of the zoning code and set a dangerous precedent. For flooding and runoff, lot 35 is flood prone. I have sent a certified letter and through regular mail pictures dating back all the way to 2011 of sitting water on this property. Do you have them? I have copies. I can.
We have your petition.
I have a copy.
Okay, just for the record, I know you provided this and you first indicated you weren't going to come, and this wouldn't be presented unless you appeared. So it's a copy. Do you have a copy to give the council?
Yeah.
Because so he has an opportunity to look at it. I'll pass it. We'll mark it as.
I have a copy to pass around.
She has a copy to pass around. Okay.
Okay. Do you
But
want me
we
to
were-
give it right?
So that way you can take a look at it while you're giving your testimony. And also, I'll give you Steve.
That one you can keep, I'll pass it up. That way they don't get mixed up, there's lots of pages.
Chuck, did you want to mark that?
Yeah, what are we gonna mark it as? Let's mark
Well,
it
they are
as.
numbered already, she numbered them 1 through 6, I think, and I
Let's-
added 7 and 8. the
Okay,
last
let's
two.
call it Boyle 1, and it's exhibits
through
1
8.
through 1 through 8. Okay. Do you want to see these now?
Okay. Can you hear me? Can you guys hear me? Where's it at? The flooding and runoff of Lot 35 is flood prone. Water already collects during storms. Any construction would obstruct natural drainage and force water onto neighboring properties. New Jersey's municipal land use law and the stormwater management rules prohibit development that blocks natural runoff or worsens flooding. Building on this lot would do exactly that. Well and septic risk on this lot is small. and this lot is wet. A septic system cannot function safely. It may meet the measurement requirements, but having saturated land, you're at risk for contaminating groundwater. My well sits close to Lot 35, and so do others in the neighborhood. Once a well is contaminated, the damage is permanent. That is not just a zoning issue, it is a public health hazard. Utility access. In addition, the rear of my property is powered by a utility pole that is only accessible through the driveway that my family has installed on Lot 35. Lending my back gate, utility crews have had to service this pole multiple times, and it also needs service now. There is a service request pending. They can only reach it through my back gate access on Lot 36 via Lot 35. Any construction on Lot 35 would obstruct that access and prevent necessary maintenance and directly threaten the utility service to my property. And neighborhood character. Our street was designed with homes properly spaced apart, allowing a house on a lot that is 60% deficient would destroy the character and disregard the purpose of zoning. It is also my understanding that the buyer has not yet purchased this property and that their contract is contingent upon this variance being granted. That makes this situation even more clear that it is not a hardship created by zoning. It is a hardship manufactured by a potential buyer attempting to acquire a drastically undersized lot. The law is settled. You cannot purchase or contract to purchase a non-conforming lot and then claim hardship. The New Jersey Supreme Court in Commons versus Westwood made clear that this is a self-imposed hardship and cannot justify a variance. New Jersey courts have also confirmed that protecting neighborhood character is a valid reason to deny variances, as Burbridge and Mine Hill Township. These cases reinforce that granting a variance here would be contrary to established law. My family has lived in this location for 38 years. We have been steady, tax-paying citizens of this township. To approve a variance that would flood our property, contaminate our well, block our utilities, and disrupt our quality of life that we have built would be deeply disturbing. Finally, I want the board to know that on September 4th, 2025, I filed a quiet title complaint in the Superior Court of New Jersey Chancery Division regarding Lot 35. That case is now pending. The existence of that litigation alone is enough to deny this variance, because approving development while ownership is disputed would expose the township and the applicant to legal risk. But I want to make something very clear. I am not asking the board to postpone or defer this matter until the court rules. Even if the quiet title action did not exist, the variance should be denied outright on its own merits, because Lot 35 is drastically undersized, flood-prone, unsafe for septic, and inconsistent with zoning law. For all of these reasons, the extreme lot deficiency, flooding and septic dangers, the obstruction of utility access, the requirements of zoning law, the municipal land use law, and stormwater management rules, New Jersey case precedent, my family's 38 years of investment as citizens, and the pending quiet title action, I respectfully urge this board to deny the variance outright. And I would just like to take a moment to respond to what they said earlier. I did see them point to this, where water runoff would be on both sides of the property, and one side of that is my driveway, which is asphalt. And I don't want it undermining the asphalt and eroding the soil. As far as the lot size, what they aren't mentioning on the previous lots with the frontage that they're describing is, I didn't hear them take into consideration when these lots were built and what the zoning laws were at that time, because they have changed. I did bring up that a saturated lot can contaminate wells, and even though the lot may fit the measurements that they propose, this is a wet piece of property. It has always been wet. It is the water runoff for the entire woods at my end of the block. And in fact, there used to be a drainage pipe on the left side of that property that ran under the road to a small basin across the street in my neighbor's yard, and that's where the water would collect. When they redid this in the, I think the 90s, they removed that pipe, and now the water sits on that property even more. If they build, not only would I have to deal with this potentially, but my neighbors will. Their driveway already floods because of this property. And the newly constructed house owners will also have to deal with this disaster as well. They did reach out to me and offer to sell me the property. I was told it was a non-conforming lot and that nothing could be done with it. So in this economy, why would I buy a property when I was told nothing could be done with it? Do you understand what I'm saying? Otherwise, they will be willing to buy it. And once I got the variance letter, I did call them and try to open up the conversation again on August 3rd, but I never received a call back. This past year, even though he did say he gave me adequate time, I've been flying to Florida once a month for my parents because they have both had major surgeries. So I fly down for the surgeries that they have, and then I fly down a month later. I am a healthcare worker, and I work 12-hour shifts. I'm out of my house for 14 hours at a time, and this has been a very challenging schedule for me. And that's why I haven't been able to respond. That's all I have to say, but you can see from the pictures that I've submitted that this is a continual problem of flooding, because I do have a picture from 2011, and I have a picture from May 16th with these rains that we've gotten, and it has flooded over this weekend as well with the rains that we just got.
Is that it?
That is it.
Thank you. Is there anyone else in the public? Please step up to the microphone. Wait to the end, Lynn.
Hi, my name is Hakima Lake. I live at 1484 Pittman Downer Road. I'm the-
You swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Thank you, Ms. Michelle. I could not have said anything better. I am the property on the other side that she's talking about that floods. And if they do build this property up, my driveway sits, I don't know, am I allowed to touch this? Am I allowed to turn this around?
Well, we have copies, so you could just tell us to where,
I'm on the other side, and my driveway is the whole side of that property. So, I mean, my driveway already gets flooded, and as Mr. Paul said, how, the flooding can mess up the integrity of hers, it's going to continue to mess up the integrity of mine, and it's going to be worse. The septic being that close, I mean, I have children, I have a young child. I do not want my water getting contaminated. I do not think that it's safe to have that septic there on such a small property. It's just gonna flood, and it's just gonna flood into my driveway, and then I'm gonna have to pay like, no one's gonna help me with that. I'm gonna have to deal with that. Ms. Michelle, I've had my property since 2011, and I've seen the floods. I've had the floods, I've had to deal with the floods, and I do not think that it's a good idea to grant this hardship. It's gonna contaminate my yard, and it's gonna mess with both of us. Both of our properties. It's not okay, it's not safe. I can't say anything better than Ms. Michelle. Ms. Michelle, I can't top that. I just want you to know that I am the other side of the property, and I'll have the same issues she's discussing. They didn't try to contact me about the property. No one said, I didn't find out anything until this letter came. So please do not allow this variance. As Ms. Michelle said, the laws were the laws for a reason. And if some properties got grandfathered in, when they were talking about the smaller lots, if they got grandfathered in, they got grandfathered in. But we put the new laws in place for a reason, and now we're trying to change that for them, and I don't think it's appropriate. and it's not safe for my family. And, you know, if you were in our shoes, you have to, you know, decide if it would be safe for yours.
Thank you. Is there anyone else in the public wishing to speak? Please step up.
I live on Pittman Downer Road. I've been there for 23 years.
Your name and
Sorry.
address.
For the record.
Amy Medusky, 1709 Pittman Downer Road.
Okay. You swear affirm to tell the truth and nothing but the truth?
Yes. So I've, lived, like I said, on Pittman Downer Road since 2001. It's always flooding. It slopes down this way. I'm like right here, and this property is like right here. Back in, I think, 2008, 2009, the flooding was so bad that FEMA came out and helped us because the flooding was so bad. I've driven down that road where the water crosses right over the street from that property when we have flooding. And I just want to warn future purchaser, I would run. I wouldn't buy that property. I wouldn't want to live there. It's just, it's like a setting spot for the water. And I feel bad for my neighbors if they're going to have future problems with their wells. And how can you put a septic system into a wetland? I don't know, I'm not an engineer, but I don't think that would work. And if they're going to build it up, what's going to happen? They build this property up, where's it going to go? It's going to go on both neighbors' property. So that's all I have to say. I just oppose it, and I hope you guys would reconsider, not selling, having this property built.
Thank you.
Thanks.
Hello, everybody. I'm from here.
Name and address.
Oh, I'm sorry. My name is Edward Boyle. I live at 1560 Pittman Downer. I'm my sister's brother.
Swear affirm to tell the truth and nothing but
Yes,
the
I
truth?
do.
Okay.
My point is that we're here because we live here, and I believe this board is appointed by people that we elect. And I think that we need to take into consideration a lot of things here, aside from the fact that this is a lack of hardship because it's a contingent sale. I don't know if they told you that. That kind of dissolves any type of hardship because, like my sister had pointed out, it is a self-made one. In addition, we're zoned agricultural business, not residential. I could understand in a residential setting where you might try to fit as many little houses as you can in, but where we live, our whole identity is small farms, Ruth Farm, And so we lost our peach orchard, and they put in this huge 55, an older place, which nobody made too much of a big deal about. And now you want to come in and even subdivide us more with these variances. He says he's an engineer. My question is this: how come when I did the Oprah, I couldn't find an engineering plan, I couldn't find a grading plan, I couldn't find anything, nothing at all? Not being an owner, he must have a legal interest, and Highlands from Millville. It's not even Gloucester County. And, like my sister had said, with a quiet title, ownership is now legally questioned. I don't know if you want to make a variance based on that. And a deference is just going to, keep us going. Another thing is that I live on that road. I know the people who subdivided their properties. No one opposed to those variances because they were in properties where the people were doing it tastefully. I think that we also need to pay attention to the fact that without the engineering plan, without any type of ownership or real legit standing, with the fact that we have an electrical right-of-way through that property to the poles in our backyard, wouldn't that cost extra money for the government to come and take those poles out? Because that's just not, feasible, it seems to me. Grant a variance on a property that's, 60% of what it needs to just incur so much chaos and so much, dispirit in a county where, it's always been kind of a farming area, and we're going to let this in. So there's a little bit more than just a property variance going on and a big company trying to come in from out of town and try to, fit their little foothold in here. Who's living in this house? It's not one of my neighbors. And one house is not going to really justify doing this to us. We have an identity, a community spirit. And this is just coming in there and saying we don't matter. It's saying that our lives, I've lived here 38 years. My mom was paying the taxes on that property. I know the story about that property. The man who built my home was a sick man. He was handicapped. He built that house from the ground up. And the lady who came down from Philadelphia is a relative of the current owner, who Viola is not here. Is he over here? She's deceased. So this woman actually used that property to help feed that man because he was poor, you know? Nobody remembers that. And it's just going to cause a hardship with all of the different development, the negative impacts on us. It would disrupt the storm, the drainage. It would reduce the privacy. Like, our house would no longer be worth living in. It would decrease our property value. And it's serious, you know? Each one of you live in the county I live in, and you're going to let somebody come in and do this to our lives. And there's also a public safety concern. Our road is a county road, okay? And people want to pile these houses up. You know what started happening? Kids started getting hit. Down the street from me, on the other end of Pittman Downer Road, a kid named Matt Milchano, who I used to babysit, was hit shortly after they put in another house. And then as it grew, more people got hit. And where they want to put this house is right between my driveway and their driveway. And there's already a well there, there's a well there, and I don't know if this thing here has it right, but my well's in the front. It's right here. And here it says found iron pipe. Do you see that? My well is in the front right corner. He doesn't have the survey to our house, obviously. I don't know how good his engineering is, but I'll tell you this, there's holes all through this. And to consider this would be a heinous crime against us, a heinous one, because they don't even have their paperwork right. And anybody who would pass this don't have their heart in the right place either, because we live here. We don't live in Millville. And that's all I got. Thank you.
Hello, my name is Clyde Johnson. I'm at 1449 Pittman Downer Road.
Swear affirm to tell the truth and nothing but the truth.
I will tell the truth.
Thank you.
Okay. I live next to my neighbor here. This is my daughter. And we have seen on heavy rains where the water in her yard coming from the road and from the opposite house brings up her front yard to 3 feet. It is so high and so wide that it looks like a pool. And if anyone adds more drainage or changes how it drains, it's going to be even more trouble. I don't know how she's going to even be able to have a septic system in her front yard because the drainage would be so bad. So that's all. I don't have a lot of facts, but I am a witness to how bad her driveway and her front yard gets flooded when we have heavy rain. That's it. Yes.
Thank you. Is there anyone else from the public wishing to speak on behalf of this application? Seeing none, is a motion to close the public portion.
So moved. Second.
All those in favor?
Aye.
Opposed? The ayes have it. Mr. Schwartz, did you have something that you wanted to say?
Well, rather than answer questions, I want to go over what was testified to. The interesting thing to start off is that, as my client has testified, before proceeding with this matter, he offered this property to his next-door neighbor, that's Michelle Boyle, who refused it. Her testimony is that nothing could be done with the property, so why should I buy it? But yet, once this application has been made, and once she's been given notice that we are taking this application, she proceeded, and there's no docket number yet, but Michelle Boyle apparently on September the 4th applied for quiet title. Quiet title basically means that she feels that she has some ownership interest in this property, and she's going to take it to the Chancery Division and hope that she can get it for free. So that's the way she's intending to get it, as opposed to taking my client up on an offer to sell the property to her or to buy any other property. I would also note comment that she made. Again, understand, I'm sure the board knows, there's been no testimony from anybody saying they are engineers. There's nobody testifying who's saying they're lawyers. She testified that she's a healthcare worker and she has personal issues, and while she has personal issues that she wishes to bring in front of the board, she feels that we're bringing this matter to the board as a personal issue, which is not. She indicates that, not as an engineer, that the wet, undersized lot septic system can't function safely. You've already heard the testimony of my engineer, and I'll bring my engineer back up again. She's not an engineer. She doesn't have any legal right or authority to testify that the septic system can't function safely. She's talking about the flooding and the runoff. The indication apparently is that somebody, and if we go back to this complaint, Viola Austin, deceased, and Barbara Taylor being the defendants, I assume she is saying that, it doesn't say it on the one page of the complaint that she attaches here, but we have to assume that they are the owners of the property. I can't tell you whether they were the owners of the property when a pipe was pulled out on the other side of the property many years ago, but clearly my clients were not the ones that did that, so it's not, there is no testimony that my clients did anything to in any way cause flooding in the neighbors across the street. As we all know in the township, we've had testimony on Clayton Road. Now we have testimony on Pittman Downer Road. There's county roads that flood. And as my engineer testified, County Road is higher than these properties. Photographs have been submitted by Ms. Boyle indicating that there is flooding on this property. As we indicated, that issue is going to be taken care of. But she also indicates that there's, from her pictures, Exhibit 3, May 16, 2025, flooding, deeper water near roadway, lot 35. That's a photograph that she took on her property. So she's not saying that lot 35 is what's causing the flooding. She's saying there's flooding on that property. That's a testimony of other people. The one person was further down the road. I couldn't get the correct address, but past Muth Farm on the other side of the road, indicating there's flooding down there. The people across the street are saying there's flooding there. My clients don't have any intention, as is required. My client has no intention to increase any of the flooding runoff going on Pittman Downer Road or going across the street. We intend to make sure that the person who buys this property is able to live on this property. She also indicates that on the utility pole access, the rear of my property is powered by utility pole accessed only through my driveway across 35 to my rear gate. Construction would block utility access and endanger power to my property. Her testimony, as I heard, is the driveway on lot 35 was installed by her family. The photograph that I have that I took on Google Earth that shows that there is no driveway. There is apparently a cleared area, and she submitted a photograph showing a gate in the back of lot 35. What she basically is saying is she illegally created a driveway on lot 35, put a gate in at the back of lot 35, as is shown by her photograph number 2, flooding lot 35 rear toward rear gate of lot 36. So apparently she's been using all these years, she's been using lot 35 as her driveway, which she's been trespassing on the property, and now she's coming to this board and saying, don't take away my illegal driveway or block me from being able to get to lot 36 by allowing anybody to develop lot 35. As the board knows, that's not her right. You don't have the authority to do anything more than say, I'm going to either grant or deny the applications that we presented. But with regard to a driveway, it's not a legal driveway. She apparently is now trying to get that driveway, whichever she says, enforced by her going to the Superior Court. And if the matter proceeds in the Superior Court, then that issue will be resolved in the Superior Court. But as she indicates, right now, this matter is not stopped. There's been no restraining order. There's nothing stopping this board from proceeding. This is the first time I'm seeing the complaint, so I know, we knew nothing about it prior to now. She indicates that, her understanding that the buyer's contract is contingent on the variance, which is certainly what I would put into any contract that I have when somebody's buying this property. That is a self-imposed hardship. This is not a self-imposed hardship. As the board is aware, when we're dealing with the law, the law is very clear. What we have, the undue hardships, a variance can be granted where there's a strict application of zoning regulations would result in undue hardship due to exceptional conditions uniquely affecting the property. That may include exceptional narrowness, shallowness, or shape of the property. What we have here clearly is showing that we've got, compared to the other properties in the area, we've got exceptional narrowness. That's why we're coming in for this variance. That's shallowness. It's not as deep as the other properties are along the way. Shape of the property, the same thing. We're dealing with a property that's that much smaller than the other properties in the area. Or exceptional topographic or physical features. Well, if it's flooding, then we get into a situation of just that, of physical features that may have to be taken care of should the board grant a variance to allow us to proceed and to do what we need to do, which requires grading plan to be submitted to the township and approved by the township so that there is not a grading problem that is going to cause any problems worse than already exist there. Jacoby versus Zoning Board of Adjustment of Borough of Englewood Cliffs. I normally don't start quoting law, as you know, but under the circumstances, the hardship must relate to the property itself, not the personal circumstances of the property. Kelly versus Borough of Oceanport Unified Planning Board. That's a matter in 2020. What we're saying here is, we're not coming in here on there's no personal reason why we're coming in here and saying that I've created a hardship on this property, therefore I want a variance. We're coming in asking for a variance as an undue hardship because of the circumstances of this built property, the size of the property, the narrowness of the property, the shallowness of the property, the circumstances that are involved in that. As the board is aware, a variance may also be granted where the purposes of the Municipal Land Use Act would be advanced by a deviation from zoning requirements and the benefits of the deviation substantially outweigh any detriments. I would say to you, one of the benefits of the variance, which would substantially outweigh any detriments, is that the benefit is this property is now going to be a house be put on it, filling put in on it, and making sure that the flooding that has been complained of is taken care of, so we don't have the flooding coming off of this property. Whether there's flooding coming off of Pittman down the road, that's a county problem, and certainly an issue that has to be dealt with from the county level. If the next door neighbors are having flooding problems, those are problems that they've got to deal with on their property and dealing with Gloucester County, Pittman down the road, Monroe Township, if Monroe Township was the one that pulled a pipe out and sent the drainage across the road. Those are issues that would be dealt with that way. But when we're dealing with the benefits of this variance, the benefits are that all along the way, what you basically have is houses, you've got a farm, you're going to have another house on this property, which is not going to have any side yard variances, rear yard variances. It's going to have the compliance except for the exceptional narrowness and size of this property. And again, the benefit of the variance substantially outweighs any detriments. And I could quote a number of different cases dealing with that. We have undue hardship that we're dealing with here and exceptional circumstances, which basically says, as the board is aware, because you've had your own training on all of this, you've heard these cases many times already. There's an undue hardship here. The benefits to deviate from the zoning requirements certainly outweigh the problems. This is why we have a zoning board of adjustment. We're dealing with adjusting the Land Use Act, adjusting the township ordinances, and allowing for these types of variances where they come about. Some properties need side yard variances, some rear yard variances, et cetera, et cetera. We just need this so that we're able to build this house, showing it as it is. Again, as part of her, Michelle Boyle's application, or letter that she submitted to this board, she's saying that Lot 35 contains the only practical access route for utility crews to reach a pole, which she presents as a picture on her property, which provides power to her property and supports streetlights for her property to illuminate the rear of her property. Bucket trucks and service vehicles can only reach this utility pole through the existing Lot 35 driveway. Again, when we're talking about personal situation, Lot 35 driveway, as her testimony is the driveway that she has created on Lot 35, as the testimony from my client has been, there is no easement, there is no driveway. I'm sorry that she was not going to have a driveway any longer should my client buy this, get what the variances, build a home on the property, and presumably prevail with the Superior Court. That drive, she'll have to find another way through her property. Again, Lot 36, which is Michelle Boyle's property, it has, and looking at a tax map, she's complaining that one of our variances is for a 100-foot frontage on Pittman Downer Road. Looking at the tax map, Michelle Boyle's property is a 100-foot frontage on Pittman Downer Road. So we're not asking for anything different than what she has on her property, as well as numerous other properties along the way. And when you look at her property is looking straight at it. On the left-hand side is her property, which wraps around to the back of Lot 35. So she's got property which obviously what has been done without being able to see it. She presumably has built sheds or garages or a house or whatever on Lot 36 to the point that there's no way she's saying a vehicle can get, or a bucket truck can get to the rear of Lot 35, which is her Lot 36. So she's created a self-imposed hardship of her own that she's going to have to work out to figure out how she's going to be able to deal with whatever is on that part of Lot 36 and the rest of her property. That's a self-imposed hardship on herself. She's not applying for any variances. She's not applying for anything here, but I don't think the board should be considering situations that is self-imposed by her. Greg, do you have anything to add to the testimony that was brought up?
We did show a well on the adjacent lot in the front right corner. We did show the well and the septic on Lot 36 and the well and septic on Lot 34. Both are shown on the grading plan, plot and grading plan, and the septic plans.
So the well for Lot 36 is at the front.
Hold on.
Just before you go on, Mr. Simmons, just want to make, the board, I think, is aware of this, but just for the record, the septic and well are outside agency approval, so they're outside of the jurisdiction of this board. So, in fact, all the measurements you're talking about, conceptually, they may be correct, but the board won't act upon whether or not your plan is accurate or not. I know the public's concerned about that. So septic and well, outside jurisdiction. You're all aware of that. You're aware of that. Just want to make sure the board is aware of that. So the board won't act upon that tonight, whether or not the well septic's in the right location. As well as Mr. Schwartz alluded to the grading plan. The grading plan, you're all familiar with this particular project. Before a building permit would be issued, if the board granted it, a grading plan would have to be submitted to the township engineer and reviewed to satisfy their concerns about any of the water conditions. So just so the board's aware of that. So they're considered outside agency approvals. I think you all know that. I'm just, for the purposes of the board, I think it's important to put that on the record.
I would just appreciate if the public remains respectful and no more back and forth. When everyone was up here, no one said a word, everyone just listened. So when they have the same right. So for us to make a decision, we need to be able to hear everyone equally, okay?
We did do soil borings on the property, and we estimated seasonal high water table to be about 9 feet. And the applicant would be willing to provide stormwater management measures to mitigate the flooding and drainage on the property.
Thank you. Thank you. I think I presented enough.
Okay. Mr. Fury? Adam's not part of this.
Okay. Just to summarize the application, as I had said previously, there were many concerns that were brought to the attention of the board, and I addressed those regarding outside agency approvals. The applicant in this particular case is, let me just go to the agenda. Okay, is seeking a lot coverage variance to allow .40 acres where 1 acre is required, lot frontage variance to allow 100 feet where 120 feet is required, and a lot width variance to allow 100 feet where 150 feet is required. The applicant is required to demonstrate before the board, and there was sworn testimony from their engineer and the contract purchaser, and Mr. Schwartz summarized it in legal argument what the legal premise is. The applicant must demonstrate sufficient special reasons why the proposed use carries out a purpose of zoning, you look at the purpose of zoning overall, or how the refusal to allow the project would impose on the applicant an undue hardship. That's a portion of it. In addition, the applicant must demonstrate that the requested use variance can be granted without substantial detriment to the public good, it's important to note, and will not substantially impair the intent and purpose of the plan and zoning ordinance. So the board is required to do your own analysis from the testimony that's been provided, from the summary of the law that's been provided. You've heard from the public what their concerns are as to whether or not the balancing test that occurs here, whether it's in favor of the applicant or whether or not it would be in favor of denial of the use variance. So that's what your goal is. Again, we've dealt with these concepts before. For the general public, they're kind of very elusive and vague concepts. I think everybody understands what the requirements are, what your job here is as the zoning board to determine whether or not the applicant has met their burden of proof. So you would need a motion to,
In the affirmative.
in the affirmative, and then vote accordingly.
Okay. Members, your pleasure in regards to application 25-18.
You would need a motion just to move it forward. Even if you vote in the negative, you still, a motion in favor of it has to be granted, then you vote individually. So someone has to make the motion to bring it to the floor. It's kind of a strange concept, but you do. Never understood that one.
Motion to approve.
Is there a second?
Second.
Roll call.
Mr. Kozak?
Yes, the lot is consistent with some lots in the area. It will also be subject to outside agency approvals, which will address the flooding, septic, and well issues that were stated.
Mr. Hefner?
As Dan stated, yes.
Mr. Carino?
Yes.
Mr. Rice?
As Dan stated, yes.
Mr. McGeehan?
Yes, as stated.
Mr. Fuder?
Yes, as stated.
Mr. Kaminsky?
Yes, I concur with Mr. Kozak.
Okay.
Thank you.
Application approved.
Why didn't you give me a chance to read that?
We had a moment to open to the public, and that's the way the procedure is done. You had your moment to talk, he had his moment to speak. We,
You understand why, just excuse me, I'll put on the record, he's just providing summary. He's not providing testimony. So he was indicating what the law was, and that's why I put it on the record that based upon the sworn testimony of the applicants, and he was just summarizing what the law was. So he really wasn't testifying, so I'm assuming that the board disregarded almost everything Mr. Schwartz said. He can't testify as to the facts. He can only summarize what the facts were, okay? Fine distinction.
So now you guys just said yes, and just referred to variance?
Yes, yes.
Why?
I think they stated it for the record, so.
yeah, we stated for a record. I'm sorry, hold on. Everyone had their chance to speak. If you want to sit around to the end and speak when all the applications are done, you can come up again at the end and speak your piece. But it's unfair for everyone else waiting in this room to hold up the procedure, okay? So if you want to stick around for another hour and a half, you can.
Okay, you can go.
Next on the agenda, application 25-16 and 0325, J and W Property LLC. Are they here?
Oh, yeah, they're getting up there in the back. The board will vote upon adopting the formal resolution at the next meeting. It has to be then published in the newspaper, and you have 45 days from that date to file any type of appeal. So it doesn't automatically go into effect. It has to be what's called perfected under the law.
And then all the outside agencies have to say yes.
And there has to be outside agency approvals. The most importantly, I think what your concerns were, the drainage issues, which will be addressed by outside agencies. But as far as any appeal process or objecting, you'd have to do that through the process. And maybe you have an attorney for the quiet title action, maybe confer with them about that.
You said we'll get something in the mail? You didn't say
No. What'll happen is the board at the next meeting, there'll be a resolution prepared memorializing what was said tonight. Okay, not every word verbatim. There's minutes being taken of the meeting. They will be adopted at the next meeting. Then it'll be published in the newspaper. It'll be 45 days from that date it's published in the newspaper before it becomes final.
What newspaper?
The newspaper or publication, whatever the publication is, South Jersey Times. Yeah. That's required under the municipal land use law. That's not Monroe Township. That's under the municipal land use law, what the requirements are for perfecting a use variance or subdivision plan.
Why did you approve this when I have litigation against that property?
Hold on. You can stick around to the end. Everyone,
We're not gonna answer, it's not a question and answer.
I understand that. If you have anything else you want to say at the end of this meeting, you can when the public is open, but we need to continue with everyone else who's waiting. So you can,
I understand that, but you gave them a chance to talk twice.
you can stick around to the end and voice your concerns. We need to continue with everyone else that's waiting.
Why didn't you tell
Please
them?
leave if you're not gonna let them continue. We have other applications that are waiting tonight. You can have a seat and speak at the end, or we're asking you please leave so we can move on.
I don't see how that's fair.
Next on the agenda, application 25-16.
Leonard Schwartz, law firm is Lottigan Schwartz, representing the applicant J&W Property 1 LLC, property at 111 East Garwood Avenue. Everybody testifying. Our planner's back here. Soon my planner walks up here, we'll get everybody sworn in.
I think he was,
Susie runs
I
up
think he
here.
was leaving. Okay, Leonard, if both these gentlemen could just state their names for the record and addresses, who they are, or all three of them. I don't know.
Yeah, go first.
111 Garwood Ave.
And you're you're the member of the LLC?
Yes.
Timothy Ryu Engineering LLC.
Urban Oros, professional planner, Rehapco Inc.
You all swear or affirm to tell the truth and nothing but the truth this evening. Thank you, gentlemen.
Just briefly, and then I'll let my experts testify. This is an application for a use variance. The reason that we need a use variance is because there are, number one, as the testimony will indicate, there was no new construction on this property. I think we said this to you, right? So as the plan shows, there are two properties, two buildings. On Lot 8, there's one building. On Lot 9, there's a second building. The second building on Lot 9 has been a two-family duplex. The property, the building on Lot 8 was commercial, was a nursery school for years, and something else above it. Is now being converted into also a duplex, two-story, also owned by the same person. In reviewing the application as Joyce and I were going forward, the concern was that Lot 8 carries its deck and part of its, the paving, as you can see from the plan, the way the paving is set up, comes over onto Lot 9, so that if we just came in for Lot 9 to deal with that part of it, and kept Lot 8 by itself, we have to do all kinds of shifting around because part of Lot 8's building is on Lot 9 and part of the paving is on Lot 9, and it's going to be causing all kinds of variance requirements more than we're dealing with here. So the determination was the best of the alternatives is to take Lot 8 and Lot 9 and consolidate those two lots owned by the same person, and as a result of consolidating them, of course, that brings up the use variance where there are two principal uses being the two duplexes. Beyond that, we also are asking for a site plan waiver. Basically, in that application, we're indicating that we meet all of the requirements for parking for this property. As the listing goes for site plan waiver, there's no employees, there's no signs, there's no, none of those various items that come under site plan waiver application. Basically is a site plan waiver because we're not building anything. We meet the parking requirements. We're not doing anything that would cause us to have to come in for a site plan approval. Everything's there. The biggest problem that exists, as will also be testified to, is because of the existence of the location, as your engineer in your engineer's report indicates, there are numerous variances that are required, side yard, rear yard, et cetera, because of the existing location of buildings, frontage, et cetera, which brings up all that. The one thing that will be testified to also is that in terms of impervious surface, that we are under the impervious surface requirements for the township, so there was no variance required for impervious surface. So with that, Tim, why don't you go ahead?
Good evening, thank you for having me here tonight. So, obviously,
Why don't you state your details so you get
Yeah, didn't want to qualify him, just give a little bit of, we want to be impressed by your background.
Sure, I'm sorry. I've done this before, once or twice, I kind of take things for granted. So my name's Timothy Ryu. I'm a professional engineer licensed in the states of Virginia, Maryland, Delaware, Pennsylvania, New Jersey, New York, Connecticut. I've testified at various planning boards, zoning boards throughout New Jersey, Pennsylvania. I do site civil land use work. I do a lot of marine structural work, bulkheads, piers, bridges, coastal analysis, and I provide professional testimony, professional witness services. I'm involved beyond this with several, unfortunately, large litigations at the moment where I serve as an expert witness. I really dislike the term, but one lawyer likes to use that term.
I think we're good. You've already impressed us. So,
Thank you.
Okay. You're going to offer him as an expert, right, Mr. Schwartz? I think you accept him on the board?
Yeah.
Okay. Thank you.
Okay. Sure. So I kind of took this over from Titan Layout Services and relied, obviously on their surveying things. They're professional land surveyors. There's some unique things here in that these buildings exist already. And everything that is proposed and consolidating is really to address the parking situation. We're not proposing any new impervious coverage. We're not proposing to modify buildings other than making the second building suitable for 2 occupancies. There's no plans to cut down trees or alter the properties in any way. So everything's existing. The parking is sort of the crux of the matter because of the configuration of the lots and the existing non-conformance of those lots. And I looked at this, when I looked at this, it's in a residential R1 zone, and I looked at it for the, and I have notes because 11 by 17, and even when I do wear my glasses, they're still small. I looked at under the 2-family or twin codes for a corner lot. So there's some things in the code that are just unique for corner lots, but going under the 2-family or twin, you need 2.25 parking spots. I've never understood the fraction of a parking spot or the fraction of people occupying a dwelling, but that's the way the code reads. So it works out to 9 spots. Now, although the spots aren't striped right now, the code requires 10 by 20 parking stalls. So there's no problem fitting 8 parking stalls in what I'll call the regular parking areas. But the driveway, the aisle, this is private property. There's nothing that says that that can't be parked in. I said there's 9 spots available. In reality, people parking, if there was a party or something, they could park 12 or 15 vehicles without a problem. So it really comes down to the parking now. This is non-conforming, but the proposed consolidation and even the adoption of a second principal use on the property really doesn't deter from the area. There's no anticipated traffic flow that would increase, right? There's probably going to be substantially less traffic flow than when it was a daycare facility. I'm sure that had much more. And in this day and age, I know Toms River, where I live, the township brings school buses to daycare facilities even, through the public schools. So really, I don't see anything as far as the pros of it as anything that really takes away from the neighborhood or lends itself to say, why doesn't this work? The negative impacts to the neighborhood are minimal. I just don't see any. The real thing that comes up under the cons is that it needs variances. But as far as the buildings go and setbacks and things like that, whether it remains as lot 8 and 9 or it's consolidated to one lot, those nonconformities already exist. There's just no changes planned that would add to anything other than a consolidation of a lot.
Going through your chart on your plan, the minimum lot area, the ordinance requires 24,500 square feet, 0.56 acres. Existing is 19,166.40, and you're proposing leaving it at the 19,166.40.
That is correct. That's for the consolidated lots.
lot.
Yes. Yeah. Everything that I set up was for the consolidated lot.
Minimum front yard building setback for the corner, minimum is 30, and we, as exists, the proposed is 15.1 feet. Minimum side yard setback 30 feet, 45 along adjacent street, and minimum side yard at one location is 14.85.
Yes, and again, when you go in, there's some exceptions, specific exceptions in the land use code and zoning for corner lot. So the rules are a little bit different. When you come down the third line, it addresses corner lots. But this is all, again, addressed as consolidated and for corner lot, with primary frontage being East Garwood.
Just want to make sure we get on the record all the variations.
Yes.
The minimum rear yard setback is, minimum per ordinance is 25 feet, and on the, looks like the existing lot, building on the existing lot 8, is at 1.1 foot side yard, side or rear of that structure.
Yeah, and I'm considering, again, East Garwood being that it's listed as 111 East Garwood, that the rear yard is parallel to East Garwood.
So we're looking at pages, not, we don't have 1.1 throughout the entire property,
No.
just in those locations.
Yes.
Minimum lot frontage per building, 120 feet per building, 240 feet required, and existing is 64.49, and we're proposing 64.49.
That's correct.
Minimum lot width, as you said, a corner lot of 115 feet, and existing proposed is 65.75.
That is correct.
Minimum lot depth, 200 feet, and as existing, and proposed is the 96.14 feet.
That is correct.
Minimum lot coverage is, for the ordinance, is 40%, existing is 34.22, and proposed is 34.22, so we're under the maximum lot coverage.
That is correct.
Maximum building height was 35 feet, and we're under the 35 foot requirement.
That is correct.
Minimum total tract area, common open space, minimum per ordinance is 10%. And basically, the open space you calculated is 65.77.
That is correct.
Then, as you testified to, the minimum off-street parking per 175-146 is 2.25 units. And basically, we show on the plan 8 strike spots. Realistically, we have 9 spots, but realistically, we could put more than the 9.
Absolutely, yes.
And on your plan, you've shown the 2 buildings where they exist.
That is correct.
And going through the rest of that testimony, well, there's no negative impact by having these variances that are pre-existing.
Exactly. I don't see where there is any negative impact. And as I stated, if the building that needs to be made into a two-family was to remain a daycare facility, there would be a lot more traffic at that intersection with cars coming and going, and whether they're, small buses or vans. I'm not sure what the schools do around here, but just with parents, caretakers bringing children in and picking children up.
Okay. Thank you. I have nothing further this week.
Okay, Adam, do you want to wait till all the professionals go, or would you like to give me your report?
Let's just wait till the end.
Oh, wait till the end.
Hello, everybody. My name is Irvin Oros. I'm a professional planner. I've been a professional planner for about 30 years. I've represented planning boards, zoning boards. I've been on this side of the aisle and that side of the aisle. My father founded Eugene Oros Associates back in 1969. He was a prominent planner throughout the state. I was holding up land use boards when I was old enough and tall enough to hold them. So I went to many, many planning board meetings as a pre-professional and as a professional. So presently I'm in the affordable housing business. We run a lot of affordable housing programs for townships. But my root is from city planning itself. I received my master's degree in city planning about 35 years ago from Rutgers University, and it's been a dream come true. It's a very diversified field, and I love what I do and wake up every morning with a smile. As you do too, right? To talk my testimony very briefly to start off, before the attorney asks some questions, I see this as a clean application from a planning standpoint. We're consolidating a lot, which your master plan talks about consolidation, which is a priority. Consolidating, and also the only uncomfortable part of the situation is the variances. But consolidating lots is a very good planning practice that towns like to see put in place, because with that, there can be control over the lot. As you can see, the owner of this lot did a significant amount of work on this property over the summer. It's a night and day situation from where it was. It's been cleaned up substantially. It's no longer a blight to the neighborhood. The downside to that is you're creating 2 additional rental units where there were 2 before, now we have a total of 4. But understand that we do have proper parking for it, and the consolidation, I think it's a slam dunk on that level. The parking itself is very conducive to a residential situation. We're not reinventing the wheel in terms of a zoning district or in the R1. So from a positive criteria situation, I think it hits all the bells and whistles. And on a negative, as the engineer spoke about, the negative has to do with the variances, but I think it's a minor consideration based on the improvement of the lot. Also, the master plan speaks of various options for residents of the Township of Monroe for housing opportunity. This provides 2 additional rental units, although they're not affordable as the ordinance or the township requires for the affordable housing program. It provides another option for residents to have in terms of housing opportunity in town, which I think is a very vital concern, especially in these hot days of affordable housing throughout the state. The roadway, in terms of the corner, having it cleaned up and have a clear right-of-way making that turn is also a beneficial, positive criteria on the site. And I just think that it's like I said, a very positive situation for the town and for residents of Monroe to see this parcel being improved upon and having new residents come into town and able to occupy another option of housing within the Township of Monroe. So that's my testimony. Like I said, I think it's a really thumbs-up situation. Thank you.
Thank you. Is that it for the professionals, Len?
Yes.
Okay, Adam, we're gonna go to our professional.
All right. So tonight's application, as we heard, is a use variance. It is for 2 principal permitted uses that will be sharing the same lot, that is to be consolidated. They're going to be 2 twin family dwellings. One is going to be obviously turned into a twin family. Just going through my letter real quick, again, I spoke about in accordance with 175, 127, no lot shall have upon it more than 1 principal permitted use. That is obviously tonight while we're here for the relief. I believe some testimony was given as to why the use variance should be granted. I do agree that there is going to be a reduction in traffic from the previous use, the commercial use. These are pre-existing non-conforming conditions. You know, when you look at the lot that was Lot 8, there wasn't much to it. The lot line actually sat, if not right on the building, right next to the building on both sides. There wasn't much frontage there. So I would agree that this consolidation is in the best interest as far as the zone plan goes and the zone scheme. We heard some testimony that the property's been cleaned up, which is always good, and removing blight. So that's a little bit speaking on the use variance and the testimony that we heard. Going into the bulk requirements, I'm gonna have a little difference on the bulk requirements here. There are requirements for a twin 2-family dwelling. I don't know if maybe there's the schedules in the back, take some looking at, but the twin 2-family dwelling unit requirements that I just looked up are a little bit different, so I'm gonna read them off just so they're on the record. And again, most of these are pre-existing conditions. There are a couple new ones that are being created because we're introducing 2-family dwellings to 1 lot. Just starting off, the minimum lot area required per unit is 7,500 square feet. The plan proposes 4 units totaling 30,000 square feet. Total area post-consolidation is proposed to be 19,166 feet, 66.40 square feet, or 0.44 acres. So as it's laid out, this is a nonconformity, as proposed, the variance is required. That is one of the variances that are being created by this consolidation. The minimum lot area, it specifies per building in our ordinance. The minimum lot area per building is 15,000 square feet. The plan proposes two-story twin dwellings on the consolidated lot. The plan does not conform to this requirement, proposing 2 buildings on a 19,166.40 square foot lot, as proposed, the variance is required. Going into the minimum front yard setback and the side yard setback, because this is a corner lot, the code says that you need to designate one street to be your front, one street to be your side. Again, a little bit of difference here, but just going by my letter, the front yard setback is to be taken off the designated street. The side yard is to be equal to 1 1/2 the normal side yard requirement. So I have taken that the setback off of Clinton Avenue shall be 30 feet as the front yard, 45 feet for the side yard. So if you don't have any objection to just swapping those around, that way the plan conforms, would that be agreeable?
No problem. And I
Okay.
believe, Mike, just for the record, before I got the plan, I did get the report and the notices that were published in the newspaper. We basically go along with what your calculations are.
Great, fantastic. I think I had the Titan plan before we got the revised plan from Rue. So I made a determination based off the Titan plan and just kind of went with it here to write a letter. So that would be the difference. Again, the minimum side yard, obviously there's a nonconformity there too. The proposed minimum side yard that we have laid out is 1.1 feet as the minimum and a 15.1 foot side yard setback. A variance is required there. The minimum rear yard, again, that's a pre-existing nonconformity. It's 14.85 feet, whereas 25 feet are required. The minimum lot frontage per unit is supposed to be 60 feet. We're proposing 64.49 feet as the minimum per unit, excuse me. Minimum lot frontage per building is to be 120 feet. We only have 64.49 feet per building, as proposed, variance is required. Minimum lot width is complied with. The minimum lot depth comes up as 96.14. Thank you for that calculation. The requirement is 200 feet. The maximum lot coverage was taken care of. We see 34.22 as the percentage for maximum lot coverage, which is good. The maximum building height, do we have anything on the maximum building height? You have less than 35 feet, that's correct?
Yeah, I didn't physically measure it. I kind of lined up angles, things, just under.
Sure, thank you. Just some general comments, just to close things out here. The number of parking spaces were good. As far as the 9th parking space goes, how many bedrooms are to be in each unit? Do we have a number on that? There are to be 3-bedroom units? Okay. All right, so RSIS requires 2, so 3-bedroom, 4 units. Technically, it's 8 would be the maximum required by RSIS. We require 9 in our ordinance. I don't see that as a large deviation.
Is that total for all 4 units?
That is, yeah, RSIS requires two stalls be provided for a 3-bedroom unit. So technically, they have 4 units requiring 8 would be technically by RSIS. Our code requires 9. The bulk table's been added, a setback boundary's been added. I would just ask that it's revised to reflect our letter and the notice, as Mr. Schwartz stated. Consolidated lot description shall be provided to the board, and new lot numbers shall be approved by the tax assessor. The only other thing that I would ask, just to close things out, Mr. Chair, is that an ADA stall be put on the lot just to cover. There is supposed to be one ADA stall that's put out there. In my opinion, I don't have any objection to the site plan waiver. Just to speak on that a little bit, I believe the ADA stall can be handled at the time of lot grading, just to check, make sure everything's complied with. I don't see any.
Additional past the 8, so 9 spots, or one of the.
That's up to the board. I don't see an objection to the 8 stalls if they just want to keep the 8. If the board sees that they should have 9 per our ordinance, I'm okay with that.
The
but-
ADA spot, is that to, would it be an additional? to
No, the ADA just has to be one of the stalls
One
on
of the
site.
stalls.
Correct. It doesn't have to be an additional stall.
No, 8. How many spots? 8, right?
They have 8 spots shown right now with the way that it's laid out.
Like a ADA.
Correct. One of them should be designated as an ADA stall.
The reality of it, if nobody's utilized it, it'll just sit there legally, not used.
That's correct, absolutely. But you don't want to run into a situation where you don't have the ADA stall on site and you're,
Why wouldn't we make it 8 plus the 1?
You absolutely
Not,
can.
right? Wouldn't that be more this way?
right, absolutely. And I still don't think that would trigger anything with site plan, even if they were to add, to your point, Mr. Kozak, another stall on site, and it would bring them into conformance with the,
Performance and
with the
that
code.
this way it wouldn't start any conflict where who spots,
Absolutely.
you know.
And as long as, I don't believe it would bring you over the lot coverage, the maximum lot coverage on site either, to add that stall in.
No.
So I think you'd be fine there as well.
I think the only thing, if we made one extra stall actually out of asphalt, and provided the 4-foot area for van access, we wouldn't be able to. And again, there's 8 stalls now that are 10 by 20, but in the, I'll call it the travel portion of the parking area, there's more than ample space to park 5, 6 more vehicles without a problem.
I see it. It's not something we should really go with by having people park on the curve there and everything. They should be in designated spots, in my opinion. Other than that, Mr. Chair, I don't have anything further.
Okay.
Through the chair, so this is going to be asphalt.
Correct.
These parking spots,
Correct.
they're going to be lined.
Correct.
So this way it will avoid, I know the location very well, that there won't be parking all over the place or along that, like he said about the drive. This way there'll be designated spots, not designated for parking, line, stripe, asphalt, that's where they should park.
Correct, exactly. And I think I took a drive by the site. I think there's already parking blocks that are out there to try and designate the stalls.
Yeah.
So a simple lineage on the
No,
asphalt, I think should be,
Which will
Just
be,
make it a
which
condition
will
of the
be
site plan
asphalt.
waiver
The
that they
driveway
have
will be asphalt.
parking lot plan.
correct. I believe it already is asphalt, is it not? It is today. So it's already asphalt, so they just got to add the lines and designate the actual spots.
Would you suggest that, Mr. Schwartz, perhaps you could do, as a condition of the site plan waiver, that the applicant provide a parking lot plan, if you will, that'll be reviewed by the planner?
Yeah, we can revise the plan, dude.
That, and you're also, I thought you were gonna ask for sidewalk waivers too. You're gonna ask for sidewalk waivers too?
Yes.
Okay, I thought so.
Now, the other thing you were talking about, all the different, like, numbers. So, do they ask for all the variances they need? We're good? Then
Yes.
later on, we won't say, oh, wait, that's, because you did a lot of calculations.
No, the one that I was concerned about, and it's been provided, was the maximum lot coverage, to make sure
So
they
they
don't
have-
have to come
they have
back.
the
But
ones
they've
they
given
need.
us the calculation that they want to go with, which is fine. A lot of these are, I mean, they're pre-existing non-conforming conditions. They're creating a couple variance conditions technically by introducing the second building on the consolidated lot. But everything that's reflected in our letter, I didn't hear any objection, should be what's
And
followed.
then have asked for the variance, all the variances you're satisfied with that they need, so we don't have to smack.
Correct.
Okay, thank you.
As
Absolutely.
I indicated, before I got this plan, I got the Collier's letter, and my public notice and notice to the neighbors basically conformed to everything that he just went over with us. So there's not a problem with that. And we're just adding, as your solicitor indicated, sidewalk waiver would also be requested, along with the site plan waiver.
Okay, members of the board, have any more questions for our professional? Seeing none, have anything else, Len?
Nothing further.
Adam, do you have anything else?
No, Mr. Chair.
Okay. Is there a motion to open to the public?
So moved.
All those in favor? Aye. Opposed? The ayes have it. Is there anyone from the public wishing to speak on behalf of this application, application number 25-16 and 03-25? Seeing none, there's a motion to close the public portion.
So moved.
All those in favor? Aye. Opposed? The ayes have it. Mr. Fury?
I just want to summarize the application. I think that the planner adequately put on the record what, or very carefully put on the record what the variances are that are being sought with respect to this application. The applicant must demonstrate to the board that the use variance is conditioned upon the applicant obtaining all outside agency approvals. It must also demonstrate, again, that I guess, the balancing test that we went over previously on the other application. There must be a balance of the negative versus the positive criteria. There's also the applicant seeking site plan waiver, as well as waiver of sidewalks. It was suggested by the engineer, or the planner/engineer, that as a condition of the site plan waiver, that the applicant provide, I guess we're gonna refer to it as a parking plan that meets the criteria set forth by the planner. Must be an motion to approve in the affirmative, and the board will vote accordingly.
Can I just say one thing? There is no professional report for the site plan waiver.
Okay.
I don't know how you want to include and make that noted about
Okay.
the ADA space
Well, the ADA space is gonna
As
be
part of the
required as
plan.
part of the parking plan
for,
that the applicant's gonna provide. Good point.
be specific.
This waiver and the thing are all together.
Yes, you can do them all together.
We don't-
You can do them all together, yeah.
Okay. Okay, members, your pleasure in regards to application 25-16 and 03-25.
Make a motion to approve.
Is there a second?
Second.
Mr. Bruce. Roll call. Bob. And then Bruce.
Okay, Mr. Doctor.
I'm sorry. Pretty much layman's terms, we're taking two non-conforming lots and just making one. So I'm good with that, yes.
Mr. Rice.
Yes.
Mr. Carino.
Yes.
Mr. Kozak.
The applicant has taken a building that has been vacant for some time and will make it a needed residential housing for Monroe in the site plan waiver also, that is existing site, yes.
Mr. McGeehan.
Yes, as stated.
Mr. Fuder.
Yes, as stated prior.
Mr. Kaminsky.
Yes. Yeah, yes, as stated.
Thank you. Thank you.
Now, the old tree that's out front, you're gonna take it down, right? That old tree there, like, with the stump?
I was thinking the same thing. I'm like, this guy's crazy.
Right? And then you're gonna register, you're gonna take care of the register and the rentals when you're ready. But that tree, the tree though, huh? Oh, yeah, I got it. Thank you.
Yes, guys, I said 3 times for you. We're going to take a 5-minute recess so the older guys can use the restroom.
The older guys last. Wow. Damn.
Okay, next on the agenda, application 25-17, Lucia Batista and Jason Garth Hugh, lot coverage variance and side yard variance. Please step up to the microphone. Can this application be deemed complete? Yes. Is there a motion to deem the application complete?
Second.
All those in favor? Aye. Opposed? The ayes have it. Mr. Fury?
Okay, if you could just both raise your right hand and state your names for the record.
Lucia Batista,
Address?
944 Kirk Road.
Sir?
Jason Garth Hugh, 944 Kirk Road.
Okay, swear or affirm to tell the truth and nothing but the truth.
Yes.
Okay, the applicant is seeking a lot coverage variance and side yard variances to allow 48%, where 40% is the maximum permitted to construct an 18 by 30 above ground pool. A side yard variance to allow 2.8 feet where 5 feet is required, and for an existing shed, and a side yard variance to allow 2.8 feet where 7.5 feet is required for an existing deck, along with any other variances that are deemed necessary to the R2 zone. The subject matter property is 944 Kirk Road.
Is there something about that?
Yeah, I did say deck.
Oh,
Yeah,
I'm
yeah.
sorry.
That's all right.
Thank you.
Not a problem.
Okay, in your own words, to explain to the board why you're here tonight?
We just want to have a pool for our kids. So we just want to put a pool on our property. We didn't know it required a percentage of the house, over a lot, so that's why we're here.
So it's existing?
No, we
Oh,
don't.
did you not-
No,
Oh, I thought
no,
you
we
said
didn't know any of variances and
Variances,
percentages of property
percentages.
until we did our survey and we brought it here, and that's when they told us that.
I think the shed wasn't on the previous survey before we bought the house.
Can you speak up into the,
Well, when we bought the house, the shed wasn't on the survey, so like when we did our survey, that's when they realized that, okay, that's new, and so we had to add that with the pool, because it was already there when we got the house. But the pool is just for our kids. My daughter, she loves to swim. Before she couldn't swim, was scared to duck her head underwater. Now she can swim. You can't get her out, and it's a little harder to go to different places. Like it's not like I go YMCA and stuff, and all that costs money. So we wanted just to have something at home. And like she has family in New York, they come down for birthday parties. It would just be a great addition to quality of life and make our kids happy. And we take care of her sister, and she couldn't swim, almost drowned her. Then went to bear paddle. She passed. Took swimming in high school. She swims for Williamstown High School, and now she's working at bear paddle. So it's like full circle. So
We like to be in the water.
yeah.
okay, members of the board had a chance to review the application. You have any questions for the applicant?
Yeah, I just have one. The shed, I understand why they're asking for what the issue is there. It's been there forever. But on a pool itself, it's not even there. If you thought about downsizing the pool, you wouldn't even have to come to us because of the lot coverage.
Oh, they told us that any size is going to be over the coverage.
No matter what size pool you put in there.
Yeah. It's like we're at the line without the pool, and with the pool we go over.
Oh, okay. Okay, I get what you're saying.
This
Okay, that's all I have.
Besides this, because
Okay.
you can actually get a swim going instead of just pitter paddling. So.
Through the chair, Chuck, the 8%, is that going to be enough for them that it won't be a problem that you calculate? it?
Yeah,
Is that
that's a good question. Who calculated the 48% versus the 40%?
Yeah, I see that.
Oh, can I speak on that?
Yeah.
They told us 44%. I just wanted to add an additional 4% just in case.
So you're good,
But
you're already going to.
they confirmed with us that it was 44% and
44.8, I think.
yes, I just wanted it to make.
No, that's what
yeah,
I was gonna-
I just didn't want, yeah.
Even more, but, okay, no, that answers the question.
Okay.
Thank you. I wanted to make
The
sure.
grading
you
waiver.
didn't
No,
come
they
back and
added it, no, they added
Yeah,
it
added
up
the
for us,
buffer.
yeah.
As far as percentage, thank you.
Okay.
I'm good. Thank you.
Okay, any more questions for the applicant from any of the members? Seeing none, is a motion to open to the public?
So moved. Second.
All those in favor?
Aye.
Opposed? The ayes have it. Is there anyone from the public wishing to speak on behalf of this application 25-17? Seeing none, is a motion to close the public portion.
So moved.
All those in favor?
Aye.
Opposed? The ayes have it. Mr. Fury.
Okay, the applicant is proposing, requesting a lot coverage variance to allow 48% where 40% is the maximum permitted to construct a 18 by 13 above ground pool. The side yard variance to allow 2.8 feet where 5 feet is required for the existing shed. And the side yard variance to allow 2.8 feet where 7.5 feet is required for the existing deck, along with any other variance. They provided testimony in support of that application.
Okay, members, your pleasure in regards to application 25-17.
Motion to approve.
Second.
Who seconded that? Bruce? Bruce?
Mr. Kozak?
It's a minimal amount that they're, addition that they're asking for lot coverage. Yes.
Mr. Rice?
Yes.
Mr. Carino?
Yes.
Mr. Hefner?
As Dan stated, yes.
Mr. McGeehan?
Yes.
Mr. Fruder?
As stated, yes.
Mr. Kaminsky?
As stated, yes.
Okay, you're approved.
Good luck.
Have
Resolution will be
fun.
prepared, and it will be memorialized at the next meeting. We'll provide you with a copy as well as the zoning officer so you can move forward with your permits.
When's the pool party?
Yeah,
Thank you. Good luck. Okay, is there a motion to open to the public?
So moved.
Is there a second? Yes, second. All those in favor? Aye. Opposed? The ayes have it. Is there anyone from the public wishing to speak on behalf of any application? Seeing none, is there a motion to close the public portion?
So moved. Second.
All those in favor?
Aye.
Opposed? The ayes have it. Approval of minutes, August 11th, 2025. Is there a motion to approve the minutes?
So moved.
Second.
All those in favor?
Aye.
Opposed? The ayes have it. Reports? Okay, next meeting is in 2 weeks. Okay. Okay, motion to adjourn?
So moved.
Second.
All those in favor?
Aye.
Opposed? The ayes have it. Thanks, guys.
All right, everybody, have a good night.
Oh, just in case anyone knows,